Hello, everyone. I can see that we've got many people joining us today, and we'll just give it a couple minutes before we actually get started. I just want to thank everybody for registering for our webinar today. I am Caroline Hunter with AmeriEstate, and next to me we've got Rich, and he oversees our client services at AmeriEstate, and he has been with us for many, many years. We also have on Jimmy Smith, who is one of our attorney providers, and he has been a lawyer for quite a while with us. Hi, Jimmy. I'll just give it another couple minutes or another minute or two before we get started, because I know I just see a lot of people logging on right now. I hope everyone's having a great day. And again, we'll just give it a couple minutes.
This is where we need to have a couple of estate planning jokes in the hopper.
Right, you've got always have quite a few of them.
Don't get me started.
Rich, yes,
No.
I know. Yes, Rich he brings quite a lot of humor to the office, which, you know, we always need that, right? Gosh, this is great. We've got a lot of people joining us. Good afternoon. We've got people in the chat saying good afternoon, good morning. Thank you all. I don't know about you, but down here in Southern California, we've got a beautiful day. So we're quite happy about that. Okay, so it's about 10:02, so I'm just going to get started. I know we've got a lot of people logging in, so this session is being recorded. So by chance, if you are coming in right now, we really haven't covered anything yet, but we will go ahead and send everybody out the replay that registered. So if you're registered and watching right now, and after you've listened to the webinar and you've got somebody that, hey, you know, this webinar was very informational, you can go ahead and forward that to them. So that's great. So again, let me just get into introductions. So again, I'm Caroline Hunter with AmeriEstate. Thank you all for attending. I really appreciate it. I've got Rich Brown. He is AmeriEstate Operations and Client Service Manager. And then on the other end too, we've got Jimmy Smith, who is one of our attorney providers, and he's been with AmeriEstate for a very, very long time. Today, we're going to talk about a great subject, and it's the type of trust, living trust, and which one is right for you. So we're going to today hopefully guide you through that and help you, give you some information that'll help you make a great decision. Couple of housekeeping items. Today, we're not providing legal advice. We're not providing any tax advice or anything like that. We're just high-level informational purposes. If you have a question, and that's what we like to do with our webinars, because it's all about you. So if you have any questions, general questions, go ahead and put them in the chat or put them in the Q&A. Actually, put them in the Q&A instead of the chat. That'll be a lot easier, but either one is fine. We'll get to it if we can. If we can't, I will download all the questions after the webinar, and we'll do our best to get back to everybody. Again, our webinar is informational, high level. If you have any specific situations, which we all do, you know, please give us a call at AmeriEstate, and we will do our best to answer your questions and put you in touch with a trust advisor who can guide you down the right path. So having said that, I'm going to turn it over to Rich, and he's going to go ahead and kick us off, and I'm going to monitor questions for everybody.
Thank you all for attending today. Thank you, Caroline, for putting this together, a very important topic. And we're very, very lucky to have Jimmy Smith. Jimmy brings an incredible amount of estate planning experience and background. And I think Jimmy's seen everything about 4 times over. Wouldn't you say, Jimmy?
Well, thanks for the kind words. We have been working together for about 20 years now. So yeah, we've seen an awful lot come down the pipe.
That's them. That's not me. I'm 20 years. No, that's them, not me. Nope. Go ahead.
Very important topic, the type of trust, and there's a lot to consider. The best news is, you know, unlike a will, a trust can provide a more custom approach to achieving the peace of mind for our clients with respect to the ultimate distribution of the estate. what we want, and the goal is to preserve the wishes of both spouses with respect to the ultimate distribution of the estate. Everybody's family is different. Some people, original marriage, original children, some blended family, second marriages, blended children, and maybe they want their estate customized so the assets go a certain direction at a certain time. Other people, they bring assets into the marriage from, for example, inheriting it from their family. Let's say you bring a home into the marriage, but you want the home to be your separate property, be distributed a certain direction in the future. But maybe if you die first, you want the surviving spouse to be able to live in that home. So these types of trusts can achieve all this and achieve the peace of mind that everybody's looking for with respect, again, to the ultimate distribution of the estate. The correct type of trust is very important. And with that, I think I'd like to approach Jimmy. One of the most common questions is whether a trust is revocable or irrevocable. And with that in mind, Jimmy, maybe you could talk about the different types of marital trusts and how revocable, irrevocable comes into play and how you vet that out of the customer in your interview process.
Okay. First, generally, if it's just a living trust, we're not really getting into specific types of irrevocable trusts that are irrevocable straight from the very beginning. These are asset situations, tax situations. We're just looking at what is a revocable living trust. So all living trusts, probate avoidance trusts, are revocable at the outset. And if you're a single person, you can revoke it, you can amend it, you can do what you want, as long as you are competent, you have capacity, and you're alive. Once you die, your trust becomes irrevocable, and your successor trustee has to follow your wishes. Now, married trusts are a little bit different, and there are three basic types of trusts and how they work with revocability and irrevocability. Now, if you take all three trusts, there are various different types of trusts beneath those that you can work with, but they all still are the same basic type. First, you have a trust, and overwhelmingly the one that's used the most is a fully revocable trust, where if one spouse passes, the surviving spouse has use and enjoyment and complete control and can do whatever they want. Essentially, you're leaving everything to each other unrestricted. The second type of trust is one where you do have a portion of it becoming irrevocable, and what triggers that is the death of the first spouse. So just remember, it's completely revocable while both of you are alive and well. If one spouse passes, then that's the triggering event. If you have so chosen, and many blended families will do this, or people who have brought in separate property, a later in life marriage, and you want to protect that portion, but you want to provide for your spouse, what you'll do is set up what's known as like an AB trust or an AC trust. What that means is when one spouse passes, the trust is then split into two pieces. Let's call it the survivor's trust and the decedent's trust. The decedent wants to make sure that their heirs are protected. So this becomes irrevocable as it relates to changing any of the beneficiaries as have been set forth by the decedent regarding the decedent's share. Decedent's share consists of 100% of their separate property and half of the community property. The survivor's share, you can do whatever you want. And essentially, when you have your survivor share, you have use and enjoyment over everything. So you are protecting your surviving spouse, but you're also further protecting any, blended family, children, or people. It's a little cumbersome in that you do have to divide your trust, but it can give you peace of mind. And when you have a blended family, I tend to go towards this one if you're not leaving everything to each other. Again, even blended families, many times it's really the primary purpose of both spouses is to take care of each other. And that's what they want to do. Hey, I'm leaving everything to my spouse. We built this. This is theirs. No restrictions. But if you do want the restrictions, such as Rich was saying, you have an inherited piece of property, or you do have a very separate type of estate, but you do want your spouse taken care of, you can use the AB and protect half of it as it, well, whatever's left of that half, as it relates to your heirs, and your surviving spouse can do whatever they want with regards to their heirs and their money. They can change that at will. And the reason I like that is I hate when there's a triggering event, someone else passes away, yet you, the survivor, are now restricted from using your own money. You earned it, you know, you've spent your life doing it. I like the fact that you would have autonomy over your money. The third type is something that I use very rarely, and that's, again, the triggering event is the death of the first spouse. And that would be a fully irrevocable trust. If one spouse passes, the surviving spouse cannot change any of the beneficiaries. They basically vest in what's known as a future interest at that time. What that does is if one spouse passes, the other spouse may live another 10, 20, 30 years. They can't change the trust. Things happen within the family. You might find a child may go bad, or something may occur where one of your heirs passes away, and you don't like what it looks like in the contingent beneficiary scheme. Again, you vested people. So I would use that only. I generally want to use that only in real specific situations where you may have a very elderly couple, and you might have certain of the children, you know, may have nefarious purposes, and they just want to make sure that if someone, you know, that someone's protected like that. But other than that, you know, those are the three basic, and we can work depending upon what your intentions are, how you're going to take care of each other, or what the property situation looks like. That's what I look at when I begin to advise as to what type of trust.
Right. And we had a question come in. A gentleman had mentioned that he's a widow and he's getting remarried this year. And he's asking, should he update his trust?
Again, that depends on what you plan to do with regard. Well, first off, what type of trust you have. If it's a straight AB trust, you would be looking potentially dividing it, and you would be updating your survivor's share. And that would really come down to, are there changes to be made? What are your intentions with regards to the new spouse and the new marriage? Are you going to have common assets? You know, these are all questions. If you're going to have your separate estate and you like the way it looks, and the spouse is coming in with their own separate estate, they like the way that looks, no, you don't need to do anything with your trust.
But regardless, I would always recommend calling into AmeriEstate for a trust review to
Sure.
look at the grand picture.
Yes.
Drill down on what you're talking about, Jimmy. But just as a side note, may wish to update the powers of attorney to reflect that spouse as the primary agent under the healthcare directive, for example.
Correct. You definitely want to do that. You do want to revisit your powers of attorney. Those are a big deal. You know, the trust takes care of everything in an orderly administration after both spouses are gone. However, those powers of attorney deal with your care while you're alive. So, you know, it's paramount that if you're incompetent or incapacitated and issues arise where power of attorney would be necessary, that you revisit those and make sure that the proper people are in place, given your set of circumstances.
And when I think about our portfolio, the powers of attorney, plus, in addition to a trust, we always provide a will, coined a pour over will, designed to push everything to the trust. But you name executors on that, and perhaps the divorced wife you'd like to remove. And right. Cut a new will.
Oh, if it's a divorce situation, if it's a widowed situation, it's different than the divorce situation.
Yeah.
You're gonna definitely be looking at it in a divorce situation. But in a widowed situation, look at, you know, you can have it looked at, make sure that what you're trying to do and your intentions are clear. Because remember that once you're gone, you can't testify if someone brings any actions or makes any claims. All a judge has to go on really is what's within that document. So let's make sure the document is tight. And again, to reiterate about the question, really it's a conversation to have between the widow or widower and the new spouse as to what they want to do for each other. Then we look at the trust and really find out what can be done. again, if you have a fully revocable trust, then you can do anything you like. If it's an AB trust, then we might be looking at a division, and then a portion of the estate can be allocated towards the new spouse.
Right. Here's an interesting question too. And we, Rich and I just had this conversation today, but baby boomers, retired, no children, they have a trustee. Can an AB trust be updated?
Oh yeah, you could, as long as both people are alive, you can do anything you want with the AB trust. Any of these trusts, the irrevocable provisions and any restrictions, what we're looking at is there has to be that trigger of the death of the first spouse. If both spouses perish together, if there's an accident, something happens, then the trust, is intact. No changes can be made because your successor trustees take over, and it's irrevocable at that point as it relates to your successor trustees. They have to adhere to your wishes. But while both spouses are alive and well with a normal revocable living trust, yeah, they can revisit, they can look at it at any time. They can change the type of trust. Just because you have an AB trust right now, if you're both alive, let's say you got a trust and you'd only been married for a year and you did have a lot of separate assets, so you went with an AB trust. Now all of a sudden it's 20 years later, you've combined everything, your marriage, you're out of any danger zones, and you really just want to get rid of the hindrance of having to divide the trust and go through and have these irrevocable provisions. Take a look at it. Just because you have an AB trust now, if you're both alive and well, you can go to a straight marital trust where it's completely irrevocable for both of your lives. So circumstances do change, and your living trust can change with them.
A question we get a lot, when on that split factor. So a lot of clients think, well, when I split that, I can't touch that half forever and ever and ever. And the answer is no. There is the ability to spend down the decedent's component to the extent you need that component to maintain a quality of life issue. But it's a common misconception that once the split is done, boy, that half is gone, can't touch it, not available to me ever and ever.
And that is a misconception. And a lot that comes to me is, well, what happens? Do I have to give this to, his kids or her kids? It's like, no, they're entitled to what is left. You have use and enjoyment during your life. There are certain restrictions. I mean, you cannot raid that decedent's trust and give it to a new spouse or give it all to your kids or, things like that. However, you have the use and enjoyment to maintain your lifestyle over all of the trust assets. But it is protected with regards to, you can't change the beneficiaries on that share.
Jimmy, I saw a question pop up, and I threw out the expression pour over will. And, maybe I'm using terms I'm familiar with, but maybe explain a little bit about what a pour over will accomplishes versus a will.
Well, essentially, a pour over will does just that. Its intention is to pour anything that you might have left out of your trust. And in the perfect world, we want everything in the trust, because then the successor trustee with death certificates can marshal all of the assets and administer the estate. Let's say the example I use is just basically, you inherit a piece of property in Iowa, and in driving home from Iowa, before you put that property into your trust, it's just in your name. That's what the lawyer did. Before you put it in your trust, there's an accident. All of a sudden, you've got a piece of property that's outside of your trust. Many times, if people get a refinance, the escrow company, they'll take it out of trust and then they forget to put it back in. You need to watch this.
Yeah.
In the event that you do have something outside the trust, the will is then used, and that goes to probate. So you're probating these assets that are outside the trust, and you're saying, hello world. Your will basically says, hello world, I have a trust. If something's outside of my trust, probate it, and I'm leaving it to my trust. So your trust is basically the heir. So what we're really trying to do is push all assets ultimately to the trust, so your successor trustee can then heed your wishes with regards to the distributions.
Though, I got a question though. What if I have a lien on my house? Can I still put my house in the trust?
Yes, absolutely. In California, anyway. I'm only speaking with regards to California. California has, by statute, stated that transfer to an inter vivos trust, which is a living trust, transfer to a living trust, a lender cannot call the note or put the kick the acceleration clause in. You can absolutely put it into your trust with a lien on it.
Yeah, sorry, that was a question that came up, and he was just going down the road on that. So
I call the pour over will a safety net. I want that safety net there. If I accidentally leave an asset out of the trust, boy, my pour over will is going to pick it up and hand it to the trust. And we do that. We do assignment of personal effects to the trust. So we do about 3 or 4 levels of things to tell the world that I want my trust to control the administration of these assets.
And I call it a safety net document as well. In the perfect world, everything's in the trust. We don't need this thing, and we don't really want to use it. But it's generally not a perfect world, and certain things happen, and we want to make sure that you're protected and what your ultimate intentions are protected.
You use that classic example of I get that call that says, hey, my parents passed away and they're sending this property to probate. I said, well, I show we put it in the trust when you created the trust, but sure enough, a lender will come along, not wish to refinance it in the name of the trust, take it out, but never tell the client the most important step, get that back in the trust. And,
right.
and usually the lender won't do that for you. That's a call we get ultimately to get that accomplished again.
Yeah. That's
very important. If you are refinancing any of your properties, make sure you get it back to the trust.
Jimmy, a question came up. What's the difference, again, real high level, between an AB trust and an AC trust?
That you're dealing with some tax issues. It's how in an AC trust, if you split the trust into 2 pieces, what happens is that portability, where you can use your deceased spouse's estate tax credit. Portability means the surviving spouse can use it all. In a C trust, what happens is that if you put a piece of property in the C trust, upon the death of the surviving spouse, everything's brought over to the surviving spouse's side. And then with portability, you're using $23 million exemption, and the property gets a full step up in basis upon the death of the second spouse, not just a partial step up in basis. That's a capital gain issue. And again, I don't want to get too deeply into tax stuff here. An AB trust was your classic married couple trust when estate tax credits were low and portability wasn't there. You needed, and that it was an IRS provision that you divide your trust. These restrictive provisions were put in place by the IRS in order to preserve the decedent's estate tax credit over everything in the B trust. However, they are the value of the asset as it relates to capital gains. Your basis is the basis as of the date of death of the first spouse to die. That's what's in the B trust. So what happens is when the surviving spouse dies, the B trust is administered, and you don't get that second step up in basis to the value on the surviving spouse's death. It remains on the deceased spouse's death. Again,
that's actually that's a great question. Yeah, because when you talk about types of trusts,
we're lurching into some tax stuff, and that's one thing that you talk about. If you're running up against the estate tax credit, the limit, and that you have a piece of property that may appreciate much higher than that, and the estate tax rates are higher than the capital gains rates, you may prefer to pay the capital gain and put it in a B trust rather than a C trust. Because if you bring it back over to the A trust and you go ballooning over and the estate taxes are higher, you would end up paying a higher rate. But that's really something not to really go down right now. That's something that would be very specific. We'd have to look deeply at that.
Right. But we want to give you the type of trust that will maximize whatever tax advantage the trust can offer. So when we talk types of trust, we're looking at that piece too. Very important.
And what's relevant in that is the amount of the estate tax credit at the time and how close you are to it.
Right. And that's great. And we've got a lot of questions, and unfortunately we won't be able to get to all of them today, but like I said earlier, I've got them all, and so we'll do our best to answer them following the webinar. So please still submit your questions. Let's talk a little bit too about what a lot of people generally call special needs trust. And we call them special needs trusts, or we call them a supplemental needs trust. So can you and Rich talk a little bit more about that?
There's a standalone special needs trust
Mhm.
that a person can create for an individual, but our average trust contains a feature, a very nice feature that can accommodate a supplemental needs child. Jimmy, do you want to
Yeah.
touch on that?
Correct. You can have a standalone special needs trust. Most really don't, unless the child was in an accident and has a lot of money of their own that needs to be protected. And then you might have a special needs trust created during life. But many times, if the special needs recipient is under the guardianship or a child with their parents or a family member who are providing for them, then they really don't have any funds of their own except for what they may be receiving from a government entity. We're looking at SSI. That's when the special needs trust comes in. So what happens is if they're receiving SSI, a single person can only have $2,000 in assets. And I think that the income, you're looking at the amount, hang on a second, I've got a note over here. The highest amount of SSI be, let's say, $794 in that range. So you're looking at potentially reducing what SSI is going to give based upon income that the individual may earn. So you have to be careful when you start to give them an allowance or something like that, and certain things that are paid for can negatively impact the SSI. So what happens is if one spouse after both spouses are gone, you can also have a special needs provision, which is within our trust, a supplemental needs provision, where the SSI recipient their share is subject to the special needs provisions and can be managed and not negatively affect their benefits. To do that, you have to be very, very careful. The first thing you look at is make sure you have a successor trustee that is in it for the long haul, or get a professional that would deal with this. What happens is a lot of people come to me and they say, oh, well, my son is handicapped, he receives SSI. I don't want him to get anything, leave everything to my daughter because she's going to provide for his care. He's going to go live with her, and that's what's going to happen. And it happens a lot. And again, you can do that. And sometimes you can't be talked out of it. However, there is a better way. What happens is when you leave everything to the well daughter, that she will take care. First off, that money becomes her money and she can use it for whatever she wants. And that also means if she gets into trouble, that money can be subject to creditor claims, her creditor's claims. So there's a lot of different things that
What if she passes away, Jimmy? I mean,
it goes to her heirs if she has not protected the individual, because it's her money. But if it's in a special needs trust, then you know that it will be allocated for what is appropriate in the special needs categories. And it would actually be there for the son, the SSI recipient, and the daughter can manage that for them. And SSI is very good about helping with this. They have pamphlets, they have they have a lot of stuff, a handbook. They will help with regards to what you can and can't do.
Remember that the supplemental needs provisions built into our trust only accommodates that beneficiary's a portion. We get the call all the time. Grandma wants to give kid a big $10,000 birthday gift. Well, we can't fund that to this supplemental need because that's outside money. Now we're talking that standalone supplemental needs trust on the side.
Correct. Absolutely. Otherwise, what happens is the trust isn't created until the death of the settlor of the living trust. The triggering mechanism is the death, which then allows that trust to be set up because it's funded. It's not funded with the $10,000 gift from grandma, birthday gift. It's funded with an inheritance. So the inheritance becomes viable after the death, and that's when the trust would be created.
No, that's a good point.
And distribution rules, we use the common expression, health, education, welfare, maintenance, and support. So not the $10,000 big screen TV, I'm afraid.
You can do a lot of things with it, but you have to be real careful. If you can provide vehicle, or if the vehicle needs an oil change, or you can also provide a vacation for the individual and a caregiver. There are things you can do, but SSI is designed to provide certain things, food, housing, things like that. And if you start to pay for those things, then SSI will begin to deem it income if it's done too much. But now we're getting into some real specific stuff, and that's where it's a case by case situation, and we're not trying to administer anybody's special needs trust here today.
Right. No, don't. Yeah. If there's any specific questions, again, just contact us at AmeriEstate, and, we will have one of our trust advisors speak with you, and then we'll determine which is the best trust for you. A couple other really good questions is that I've got one here. Well, actually, that's just a little bit too specific, but let's talk about, and I think we touched a little bit on before, about blended families. Here's a question. There's a blended family and an AB trust. Should each spouse list executors of their choosing separately so that the inheritance of the deceased spouse is protected?
Generally, no.
Okay.
Generally, what will happen is if something happens to one spouse, the other spouse is not going to want to have someone else come in and answer to them for whatever they want to do. The surviving spouse will be the trustee over the entire trust. I generally prefer that you get a representative of each side. So if you have a blended family, have one of mom's kids work as a co-trustee with one of dad's kids. That way, no one can say anybody's hiding the ball. You're not, everything is looked at by everybody. You can get to the bottom of a lot of issues without all of a sudden deciding, well, we're going to split this up. It's going to be 2 trusts, and Joey over here and Cindy over there. A lot of times when you are married, it's just not that neat. If you have something that's a bright line situation, even as a married couple, then get 2 trusts immediately. Each of you can have your own separate trust, and then you don't blur those lines. If you want your own trust, but you want your spouse to be able to reside in your house, then you spell that out in your trust, and whoever your trustee will be, will have to adhere to your wishes, and a life estate would be set up. So you see, in my opinion, it's better. I would rather have someone you trust or a few people you trust as co-trustees over the entire situation. If you do have 2 really distinct lives or assets, your asset pictures like that already, you can get 2 trusts, and it's really a cleaner way to go.
Yeah. We see a lot advertising for, do-it-yourself living trusts. And speaking that you're attorney, obviously with AmeriEstate, I don't know if you just want to touch base a little bit about why it would be good to do it yourself or not so good to do it yourself.
I can interject one thought. When something goes wrong, or when there's a question in the future, where do you go for that correspondence? I mean, in the AmeriEstate environment, we're here as a legal access plan. If the original drafting attorney falls off the face of the earth, we can get you the proper resource.
There is a lot of support, and I will tell you that a lot of times when someone comes in the door in the last 20 years, I'm asked to do a review of their existing trust, and what happens is a lot of these people went out and did their own trusts and really wanted somebody to look at them. And generally speaking, they're really not worth what. It's my opinion, but people are going to do what they want to do. But I will tell you, I create a lot of restating trusts that were do-it-yourselfers, and there's a reason for that.
Yeah.
And very often funding aspects are overlooked. I mean, sure, you got this trust, you got your pile of paper, has all your wishes in there, but unless you take the steps to fund assets to the trust, do a deed for the real estate, go down to the bank and transfer that asset to the trust, you've come woefully short of completing everything that document and the features of that document.
Yeah.
Very true. When you're filling in the blanks online, rarely are you going to have them telling you what and how to fund your trust, what to do with retirement accounts. And then you get into a situation where if you're not aware of certain obscure laws that may affect you, like a rule against perpetuities and a pretermitted heir, you know, these are types of things that I delve into and look at and ask questions about when I'm speaking with a client, because I know what to do with those. But if you don't know that they exist, you may feel that you're just going to leave out an heir because they're estranged from the family and you want to forget about them. You can't do that. You want to name them. You have to show your intention. But if you don't know the answer to that question, then your self-trust, you know, your do-it-yourself trust is all of a sudden going to be deficient, and it's going to create some problems and make your intended heirs vulnerable. So be very careful. If you're going
Just
to,
so you know, Jimmy constantly updates the trust for purposes of law changes. They standardize no contest clause language in California. Jimmy says, we're updating this trust, and we're offering each and every client that got our trust that update as well.
If you're going to do it yourself, be very, very careful. You're going to spend a lot of hours making sure that you've crossed all those T's and dotted those I's.
Absolutely. What if you have assets outside the United States? Can you put those into your trust?
Depends on the asset. Real property, not going to happen. Foreign countries are very, very jealous. They guard their real property jealously. They're not going to let a United States court dictate what's going to be done with their property. So if you've got property in Chile, or you have property in Costa Rica or France, you're going to want to talk to somebody there about dealing with the estate planning issues of that country, because there are a lot of different things that go on. So you will have an ancillary estate plan for those foreign assets.
I always wondered, Jimmy, if in a foreign country, they could make the beneficiary of that will or that foreign trust the U.S. trust. I always suggest to clients, you know, hey, you know,
I don't know
make
the
that
answer
determination.
to that. See, I don't know the answer to that question, and it might be country by country. You know,
Exactly.
it's just the way that's going to be.
Exactly.
Sorry, we've got so many questions. I'm trying to type and do stuff at the same time. What other recommendations or what other common questions do you get about situations that are in the commonplace that like may not be some of the trusts that you touched upon? You know, I mean, we've got the, like, you know, so you just talk about that, or, you know, some that are popular that maybe a lot of people don't talk about.
Not sure how to answer
Well,
that.
Yeah, I mean,
for example, like an irrevocable trust for an asset protection situation,
exactly, yeah.
custom environment.
Oh, again, that's really getting into something. If people are asking questions like that, that should probably be its own seminar. There are certain things, you know, grantor retained asset trust, you know, spousal limited, you know, access trust, these SLATs, GRATs, ILETs, all of these things, these acronyms are designed to remove a piece of property from your estate to protect that. It's irrevocable. You're no longer the trustee of it. There are a lot of restrictions on that, so it's not in your trust estate. With the $23 million plus that can be protected now, the usage of those isn't quite as necessary. It's really a specific situation. And that's something that we would have to sit down and really take apart before we could discuss what type of trust would really be the best for that.
Yeah. Now, let's say my husband and I, we have a living trust, and we get divorced. Now, is everything null and void, or do we just kind of status quo? What do you recommend?
It's funny. I have seen issues where a lot of times if you get a divorce and once the property division has occurred and everything's gone through the courts, all the property's been taken out of the trust and distributed to you personally. When that happens, a lot of times, even in the dissolution order, you'll see that the trust is revoked right there on its face in the order. I generally will advise clients that are divorced that come to me and say, well, I had a living trust and everything's out of it now because I was divorced. Has the trust been revoked? If it has not, I would want to prepare a revocation just so that we don't have a potentially competing document out there. in very rare instances, the divorce is so friendly that they really want to keep their assets together and they both have one child and everything's okay. And let's just keep the trust, not the marriage, but the trust. So it's really whatever your circumstance is at the time. But unless your dissolution specifically address the trust, I would like to have a revocation. It's a real simple thing to do.
And each of those parties is going to need a fresh trust independently.
Correct.
So back to AmeriEstate, by the way.
Correct.
Yes, absolutely. I know this can be a very touchy and delicate subject, but we had a question come in. Can we do, or can living trusts be done for non-US citizens?
Yes.
Okay.
Yes, they can. Again, we're looking at making sure that they have to be domiciled here. You do have to be living here. Your assets are here. I'm not doing a trust for someone who just happens to be in the United States and they're really not working here, but they might be here for an extended time with family. That's really not what we want to do. But if you do have a green card, or if you've been here forever, or a lot of times we do trusts for one's a U.S. citizen and the spouse may not be a U.S. citizen. So you've got these different things that can be done to protect the assets. Some tax issues come into play there because the estate tax credit, there are some limitations. There are some things that need to be discussed if you have, if you're not a United States citizen or
It's been suggested.
If you're a permanent resident, fine.
Mm-hmm.
It's been suggested that a foreign citizen might nominate a U.S. citizen as a successor trustee because the IRS, if there's trust issues, doesn't
Correct.
want to have to chase somebody all the way around the world for trust administration. So
Absolutely.
nominate a U.S. citizen to be available for that purpose.
Correct.
Yeah. This is a good problem to have. Question is, does the money my child inherited from a living trust count towards the 11.7 million lifetime gift tax exemption?
No, if they inherited it, it goes towards the estate tax credit of the decedent. The gift, any gift implications are during life. The inheritance is an inheritance. It's not deemed a gift with regards to taxation issues. And if the gift is given during life, it goes towards the giftor, not the giftee's estate tax or credit. It goes towards the giftor's gift tax credit. Now, this individual, the son who inherited this amount from grandma, when they die, anything remaining goes towards their estate tax credit to the next one. But no, it's from it deals with the credits of the person giving, not the person receiving.
Okay. That's great. I love this question. And what are our fees? And again, we do have, well, not again, but AmeriEstate offers flat fees. It's very specific too. So that's a hard question to ask because there's many factors involved. If you're single, if you're married, if you have property, how much property do you have? So there's certain things that come into play. Our fees are a lot less than typical attorney fees, but contact us at AmeriEstate and we will have you speak with one of our trust advisors who can talk to you about fees.
It would be a custom quote depending on the pieces of real estate. Do you have business assignments in play that? Yeah. So do you carry back a deed of trust that would need to be assigned? Lots of features. So the raw trust is a prepackaged pricing, but then some of the ancillary work is added for the custom quote. Yeah.
We've been talking a lot about putting property under a trust, and you've got these things, but here's something that's very common, especially right now, Jimmy, is that let's say that I own a business, whether it's big or small. I'm a YouTuber. Okay. And, I own my own company. I'm married. I've got property. What type of, owning a business? So I own a business. Should that business be put in a living trust?
Excellent question. And again, it's a case by case basis, but generally, like if you are a consultant and if something happens to you, you basically get paid. You don't have a large business account. You don't have employees. If you go, the business is gone. At that particular point, there's nothing to probate. Without you, the consultant, it's all over. So with that, generally, it doesn't need to be put in the trust, again, case by case basis. But if you have, if you own that tire shop, or you are that YouTuber, or what do they call them? Media, what are they? Drivers, whatever they are.
Social media influencers.
Influencers, yeah.
Yes, yeah.
But if whatever you are doing could be worth money, if you've got a few zeros on the end of it after you're gone, then you definitely want it into your trust. And easily, if it could be sold for over $150,000, it really has to go in your trust. Under that, you might be looking at a small estate affidavit or another way to kind of slay that, but it is still an extra step that your successor trustee would have to go through. If it's in the trust, they don't have to deal with any of those issues.
Okay. Well, and here's another question. And on top of that,
and again, I'm sorry, one caveat before you, don't mean to cut you off. $150,000, again, California. If you guys are watching somewhere else, you really need to talk to an attorney in your state to see really how that goes in terms of funding and what triggers the full-blown probate there.
Right.
I sort of look for a compelling reason not to title an asset to a trust, because mostly that's what we eat, breathe, and sleep around here. Assuring probate avoidance with the trust, but there are compelling reasons not to title an asset to the trust, but that would be a custom discussion with your attorney.
Right.
Correct. Absolutely.
Does it matter? Okay, so again, I own my company. I'm an influencer, YouTuber, and I'm bringing on people because I'm just so busy and successful. Should I set up, if I have an LLC, or if I just name my company, Caroline's Consulting? Does it matter if I'm an LLC or just car washing business, whatever, to be in the trust?
No. Whatever type of business it is, whether it's an LLC or your portion of a partnership, or whether it's a full-blown corporation or even a sole proprietorship, we can get it to the trust. We assign it in different ways, but we make sure it gets to the trust.
Good. Okay. We're at 10:47 right now, and we do have a hard stop at 10:50. Jimmy has another appointment, and he's just been so gracious to give us this time today, along with Rich. And we've got, I'm so excited. There's just so many great questions. And again, we're not gonna be able to get to them.
I've been seeing these questions. This is great. We could do this all day.
And I wish
excellent questions.
You know what? We're going to do a podcast. I think we need to be podcasters now and then go into YouTubers. But anyway, just before we end, and again, you've addressed a question. I will make sure that I somehow respond to every single question. The process, what will happen is I will download those. I will review them. I will send them to either Rich or Jimmy, give them a couple of days to be able to get back to you, and then we'll send everything out. Again, replays will be sent out. I've had a lot of people ask, are we going to be doing future webinars? Absolutely. We look at ourselves as we've been in business since 1998. We have over 40,000 clients. And we like to consider ourselves the thought leader for estate planning. And so we are definitely doing monthly webinars that we feel that are topics that are that'll be interesting to you. So please join our newsletter list, and you will receive information about the upcoming webinars. And I had a lot of questions come up that were specific about taxes. We did, and Jimmy, you were a part of this, we did 2 webinars, one in October and then in December, that were specific about taxes. And we had Shauna on, who is a tax, a CPA. And if you're interested in those, give me an email at Caroline@AmeriEstate.com, and I can send you the replays. And before you jump off, Jimmy and Rich, any closing comments, ideas, thoughts, just, for everyone out there?
I like to encourage people to call AmeriEstate and get hooked up with our trust advisors. They're highly educated and they really do a nice job of setting it up on the way to the attorney. We at AmeriEstate like to think that we're very educational in this process. A lot of attorneys, a lot of companies will hand you the big pile of paper, sign here, congratulations, have a nice day. We like it to understand what you're accomplishing and how you've accomplished that. And then that goes to you, the clients, and your children as well in the future when they go to execute those documents or utilize them. We want to be here and educate them on that process as well.
Right.
Sure.
And AmeriEstate's in several different states. So, if you've watched this and you're not in California, again, I'm licensed in California, so I'm not trying to give you legal advice where somebody in your state, you might want state specific advice. You definitely want to follow up with that. And call AmeriEstate regardless what state you're in, because maybe they've got the attorneys there for you as well.
Yeah, we can refer you. And I've seen a lot of questions come into is like, if somebody does have a living trust, great. We're so happy that you do. You can give us a call at AmeriEstate if you've got specific questions, and we can do a trust review for you. And so we'll be able to review your trust. And we highly recommend that everybody, at least every couple of years, do a trust review. Just things change. And it's always good to have someone take a look at it.
And incorporated with the trust review is, review your will, review your powers of attorney. Very important to review your funding. So it's very comprehensive.
Yeah.
And if you have a trust that you like, if it looks like your trust is solid, many times attorneys will just give you that one document. So if you just have a trust, at least take a look at getting all of the ancillary documents. Get a package to complete everything. Make sure you have that pour over will and the powers of attorney that are necessary. So even if you have the trust document, that it really shouldn't stop there. There are some things that would be very helpful to you both during life and when you're gone.
Right.
We coin it an estate planning portfolio.
Yes, exactly. And here's something to think about too, is that if you've got children or grandchildren who are getting ready to graduate college and they are turning 18, you really need to think about their future and their well-being too, is that once they turn 18, they are legal adults. And so as a parent, and I'm a parent, my children aren't quite that old yet, but if something were to happen to them, we're not able to get access to their information, no matter how old they are, even if they're in their early 20s and, they've got great bank accounts. You cannot go into the bank and take care of their banking issues, paying their bills. So it's healthcare directive, absolutely, if something were to happen to them, even getting their grades in college. And so we have what's called in case of emergency kit, and it does include the powers of attorney, the healthcare directives, things that they would need when they turn 18. And so so you can give us a call and we can walk you through that as well. But Jimmy, I know you've got to run. To get onto our mailing list, just go to AmeriEstate.com, scroll down to the bottom, and there's a link to go ahead and join our mailing list. And again, Jimmy and Rich and everybody out there, thank you for attending our webinar today. We will put on additional webinars, and we just hope that we provided you with educational information and we're able to help answer some of your questions.
Thank you guys for having me.
Thank you, Jimmy. Thank you, Caroline.
Thank you. Everyone have a wonderful day.